Well, good afternoon, everyone, and thank you for joining us for this Soft Drinks Industry Levy and Alcohol Wholesale Registration Scheme webinar. I'm joined with Amelia and Anthony, and I'll just pass you over now.
Welcome, everybody. Thank you for attending today. My name's Anthony, and I'm the Indirect Tax Manager based at BDO's Manchester office. Today, I'll be talking about the Soft Drinks Industry Levy. When I'm finished, I'll hand over to my colleague, Amelia, who'll be talking about the AWRS Alcohol Wholesaler Registration Scheme. After that, we intend to take roughly 10 minutes for questions and answers. But don't worry, there'll be a handout covering all these subjects discussed today, so there's no need to make copious amounts of notes. Just sit back and listen as you please, really. Okay, we'll start off. The Soft Drinks Industry Levy, which will be administered by HMRC, has a proposed start date of April 2018. It's going to apply to producers and importers of soft drinks who must register to pay the levy by submitting returns. The idea behind the levy is to encourage UK producers and importers of added sugar drinks to reformulate their products to reduce sugar content. The levy is also aimed at reducing portion sizes for added sugar drinks in order to encourage importers to bring in reformulated drinks with lower added sugar, encouraging consumers of soft drinks to move to healthier choices. That's the idea behind it all. Now, the money raised for this will fund programmes to encourage physical activity and balanced diet within schools throughout the United Kingdom. The Draft Finance Bill of 2017, published after the Autumn Statement, set out the scope of the levy by reference to the type of product, added sugar and sugar thresholds, as well as drinks which are outside the scope of the levy. Who's likely to be affected by this? The levy will directly affect UK producers and importers of soft drinks, whilst having a downstream effect on retailers, supermarkets, pubs, clubs, restaurants, and members of the public. No doubt UK producers of soft drinks will have to pass on some of the cost, or possibly all of it, to the consumer. Right, now there's going to be two rates of levy. The lower rate, which will apply to added sugar drinks with a total content of 5 grams or more of sugar. That's not just added sugar ingredients, but the total contents per 100 millimetres, that's 1 litre, of prepared drink. The higher rate is going to be for drinks that have 8 grams or more per 100 millilitres, again, per litre of drink. So the rate, you've got 18 pence per litre for the lower rate, and HMRC have set the current higher rate, or will be the higher rate, at 24 pence per litre. Now, packaged soft drinks contained added sugar if any of the following are combined with the ingredients at any stage in the production of that soft drink: calorific monosaccharides or disaccharides, a substance containing calorific monosaccharides or disaccharides, and a packaged soft drink doesn't contain added sugar ingredients only if reason of containing fruit juice, vegetable juice or milk, or any combination of them. Now, the commissioners of HMRC may, through their own regulations, make provisions about what or what is not to be treated for the purposes of the levy as fruit juice, vegetable juice or milk. I just hasten to add there that, don't worry, the sort of devil in the detail that I've just read out will be in the handout, so please don't feel that you have to scribble loads of things down. Don't. Okay, moving on. Next section we're covering is exemptions. Now, the levy will not apply to a drink where no sugar is added. Milk-based drinks and milk substitute drinks won't be subject to the levy provided certain conditions are met. Alcoholic drinks with an alcohol by volume of up to 1.2% are within the scope of the levy. However, the government is making provision to exclude certain drinks that fall within this category from the levy. Medicaments will also be exempted from the levy. Some small producers may also be exempt from the levy too. Now, the exempt soft drinks, just to recap, you've got the following, which will be milk-based products, milk substitute drinks, alcohol substitute drinks, and soft drinks of a specified description which are used for medicinal or other specified purposes. Now, I am just going to give you a quick definition of what HMRC classes as, for instance, a milk-based drink, which will be, it means a soft drink that contains at least 75 millilitres of milk per 100 millilitres of prepared drink. Or another example, you have a milk substitute drink, means it's a soft drink which contains at least the specified quantities of calcium and also meet such other conditions as may be specified by HMRC. An alcoholic substitute drink pretty much means a drink which is familiar to a particular kind of alcohol beverage and meets such other conditions as may be specified. So the Commissioners of HMRC will regulate to make further provision about the criteria determining what is and what is not to be treated as a soft drink. In addition to the exemptions, we have export credits. This will enable a person liable to pay soft drinks levy to get a credit against their liability in respect of any exported drinks. For example, for the sale or provision of a chargeable drink on a passenger transport operating between the UK and a place outside of the United Kingdom, it's to be treated as an export out of the UK for the purposes of the levy. So HMRC are looking to legislate in order to make necessary provisions to put these things into place. Now, just as a slight aside and a bit of interesting information, on March 31st of this year, there was an article in the press written about the Brexit report. It was their 5th annual soft drinks review. Okay, and it reported a change in consumer behaviour with zero or low sugar drink sales increasing significantly as consumption of higher sugar drinks is basically on the fall. Now, the levy, even though it's not introduced yet, is already driving reformation according to this report. And just to sort of supplement that, recently we heard that Tesco cut sugar in their own brand drinks to avoid the sugar tax. So it's already having positive behavioural changes within the industry. That was taken from an article in The Guardian. It was actually November of last year. So as you can see, some companies are well advanced in their thinking about how they're going to tackle the levy or to avoid it for that matter. Now, Chancellor of the Exchequer Philip Hammond has already confirmed that whatever money the government have committed to the schools will be, of course, honoured regardless of less levy collected at the end of the day. Now, as with all HMRC's regime, there'll be penalties for non-compliance or failure to make returns, etc. So HMRC have made it quite clear that there'll be failure to notify penalties for those liable to register who have not done so, which will fall under Schedule 41 of Finance Act 2008. In addition, there will be penalties for failure to comply with requirements relating to returns, which will be Schedule 24 of the Finance Act 2007. And again, please don't write this down. It is in the handout. Both types of penalty can be incredibly high and can be based on potential lost revenue and are non-reconcilable, so you can't claim them back in any kind of a return. So it's very, very important to make sure that you've got all your ducks in a row before this levy kicks off if it's going to affect you in any way. Now, final slide is covering Brexit and what it means for importers and exporters of soft drinks. Theresa May triggered Article 50 of the Lisbon Treaty on the 29th of March 2017. What we do know is Mrs May said in her February address to Parliament, she made it quite clear that there wouldn't be a Turkish-style union with the EU, very similar to what Turkey have in terms of tariff-free goods with no origin rules. Therefore, unless something changes, that leaves us with two other possibilities. One is we could agree some sort of a free trade deal based on what we call origin rules, which can sometimes be rather complex and burdensome. They're certainly not straightforward. The other possibility is that we fall back on WTO, World Trade Organization, most favoured nation rates, which will apply on the date the United Kingdom leaves the European Union. Now, whatever happens 2 years from now, exports, stroke import into the European Union will have to be declared to HMRC and receive a positive customs clearance when departing from or arriving into the United Kingdom. Equally, your exports, which will have to be customs cleared when they arrive in the European Union with all the taxes and duties paid prior to release to free circulation. I'd like to give you just a basic example of what an export might look like post-Brexit. You might export soft drinks to Italy. When we Brexit, it will be your responsibility to arrange for the customs export entry to be made, which must be presented to HMRC and customs cleared prior to exporting your goods. The goods would then travel to Italy, where again they would have to be declared to Italian customs authorities in this case, All EU duties and taxes would have to be payable at whatever rate is applicable, assuming that there is no free trade deal, of course. An example on imports, if you import soft drinks from, say, Spain, when we Brexit, those drinks will have to be customs cleared on arrival at the UK port or airport of arrival. Any customs duty, again, unless we have a free trade agreement or something like that, or some kind of a tariff-free agreement on certain products, will have to be payable along with any import VAT. And your goods will have to be customs cleared before they can be released. In addition to that, there will be further costs. Inevitably, freight forwarders are going to charge clearance fees for both the export and import declarations. From prior experience of my own, freight forwarder can charge anywhere between £15 and £35 for an export declaration, and anything from between £30 to £75 for an import declaration. So that's a phenomenal cost if you're dispatching goods in large volumes on a regular basis to the European Union post-Brexit, or vice versa. Okay, now here's just a finishing thought, really. What happens if there was no trade deal? Okay, we know there are quite high tariffs on sugary drinks that are already, they're already very high for importers that currently import from third countries outside of the European Union. Post-Brexit, if you were to import soft drinks from the EU, and assuming there was no trade deal, you could find yourself on the end of quite an unpleasant double whammy situation where you pay a very high tariff on the sugar content for your imported soft drinks, as well as the UK Soft Drinks Levy when you receive the goods. Now, if ever there was a sobering thought, pardon the pun, that would be it. Okay, I'm now going to pass on to Ornelia, who's going to discuss the Alcohol Wholesaler Registration Scheme. And just to remind you all as well, we'll have that questions and answers session at the end of Ornelia's session. Thank you, Ornelia.
Hello, everyone. So, Alcohol Wholesaler Registration Scheme. So if you're a wholesaler, then you should have signed up to HMRC's Alcohol Wholesale Registration Scheme, AWRS, before the 31st of March 2016. However, you should be aware of your obligations under the AWRS to show due care and attention when you're purchasing alcohol, or you may find yourself on the wrong end of an excise duty civil evasion penalty, which are issued by HMRC under the Finance Act, in general under Schedule 41, which are so-called wrongdoing penalties. So when you need to apply, so you'll need to apply for AWRS if you satisfy all of the following: that you're a business, you sell or arrange the sale of alcohol, and you have an establishment in the UK. Your sales are made after the point where excise duty is due. So somewhere in the supply chain for alcohol sold in the UK, duty must be paid to HMRC. And any sales to other businesses are made for onward sale or supply. So the types of businesses that need to register are typically the following. So you've got businesses like breweries, wine producers, vineyards, spirit producers, wine importers, and general wholesalers selling alcohol, so including your cash and carry businesses. So you'll also have to apply if you're supplying alcohol to other businesses for resale, as let's say as a broker or a retailer who makes regular sales to other businesses, or an auctioneer or a charity, and you're supplying alcohol to businesses for resale. So there are certain exclusions to the scheme, what we call incidental sales. So if you don't need to register for AWRS, if you're a trader who's mainly a retailer and you have a retail license and you don't set out to make sales of alcohol to other businesses, and you only make wholesale sales that take place unintentionally in the course of your retail activity and without prior knowledge. So, for example, like sales through a supermarket checkout. Or you knowingly make wholesale sales, but they're uninvited and are more so on an exceptional basis. So, for example, your annual village fete. So these are known as incidental expenses, incidental sales. So there's also corporate group sales, which is also exclusion to the scheme. So if wholesale sales of alcohol between members of the same corporate group, then you are excluded from the scheme and there's no need to register for AWRS. If wholesale sales are made outside of the corporate group, then the companies involved will need to register. So if there's more than one company from the same group who makes wholesale sales, then those companies can apply for a group AWRS registration. So the requirements of AWRS, so only applicants who can demonstrate that they're fit and proper to carry out this controlled activity of selling alcohol will be granted approval. So this means HMRC must be satisfied the business is genuine and that all persons within an important role or interest in it are law-abiding, responsible, don't pose any significant threat in terms of potential revenue as a result of non-compliance or fraud. So HMRC will assess all applicants, and it's not just the legal entity of the business, but all partners, directors and other key persons against a number of fit and proper criteria, just to establish and get comfortable that there's no evidence of illicit trading indicating that the business or key individuals pose a serious threat to the revenue. For examples of seizures of goods in the past, trading with unapproved persons, or trading unapproved yourself really, or if you've got any previously revoked, let's say, warehouse approvals or any disqualified directors. And it's basically any links to connections with criminal or fraudulent activity, and then there's some form of attempt to deceive. And also HMRC will also look at your payment history and your debtor history. So what they want to be satisfied is that you have good due diligence procedures in place covering your dealings with your customers and your suppliers. So due diligence procedures. So from the 1st of April 2017, retailers must check that the wholesalers are registered with HMRC under AWRS before purchasing any alcohol from them. Retailers themselves can be opened up to assessments and penalties for evasion of duty. So before the 1st of April 2017, retailers who bought from wholesalers should have made sure that they have enough proof that the excise goods they've purchased have actually been excise duty paid. So if a retailer has any doubts over the credibility of the wholesaler, or you can't obtain sufficient evidence that the goods have been excise duty paid, then you shouldn't purchase them. So you will need to check that the wholesaler has registered with HMRC and has the unique AWRS reference number. So if you are a trade buyer or wholesaler, you will be able to use the online lookup service of approved wholesalers to check that the wholesalers you're buying from are registered. And it's a condition of your approval as an alcohol wholesaler that you objectively assess the risks of alcohol duty fraud within your supply chain. You put in reasonable and proportionate checks in your day-to-day trading to identify transactions that may lead to fraud or involve goods on which duty may have been evaded. You have procedures in place to take timely and effective mitigating action where a risk of fraud is identified. And more importantly, you document the checks that you carry out, and you have appropriate management governance in place to make sure that those checks continue to be carried out. So what HMRC refer to are the fitted checks, the due diligence risk indicators, and to be used as a guide. It's not something that's set in stone and not completely relied on, but it's looking at, for the F, the financial health, so undertake credit checks, establish contract payment terms, and understand the kind of offer of, is it commercially viable payment terms that you're being offered. Look at the identity, so AWRS approval status check on the system. Double check the company details against other sources. Identify whether the company is a member of a, let's say, relevant trade association. You obtain copies of incorporation, excise and VAT registration certificates where appropriate. Identify and evidence, if possible, the history of who you've been trading with. So then, looking at the terms of contracts, payments and credit agreements, who the payment is being made to, so if there's a third party involved, is there a sound commercial reason for this? If the payment's been made from overseas, confirm how it's made. If buying through a broker, determine whether it's worth it, ideally buy direct. If transactions are financed by a third party, check to see if they're regulated by a financial body such as a bank. Transport, who is responsible for the transport? Are costs of goods inclusive of transport? So does that make the price, let's say, unrealistic? Retain details of delivery vehicles and expected variations to any contract, any transport arrangements that have been recorded. Existence or provenance. Are the goods actually duty paid? So you're looking at how the trader contacted you in the first place, if the goods actually exist, if you can inspect the goods before purchasing them, if they're in a good condition and not damaged, if the quantities on offer seem credible for the type of business that you intend trading with, and that you get sufficient detail to satisfy yourself that the goods are duty paid. So that's easier the closer you are in the supply chain to production. So the deal itself, is it too good to be true? If it is, then obviously caution there. Why is it being offered? How does the price compete when compared to, let's say, competitors? Is it too low? How old are the goods? If they're very old, seek an explanation as to the actual provenance of the goods. So the maintenance side, so you've got existing suppliers, customers. So what you should do is perform regular supply chain checks. Know the people you're trading with, so again with your new and existing business relationships. Businesses change over time with different management, so once a compliant business may change paths with different personnel. Take care when you're negotiating new deals, and the same checks still apply. Having an AWRS number is not sufficient. You do need to do full due diligence checks in order to commence trading with another company. And more importantly, you must be able to evidence the due diligence checks on all suppliers and customers, and ensure you have sufficient evidence of the checks being carried out on each supplier and customer, so to present to HMRC in the event that they come out and carry out an audit. And keep sufficient records in order to remain as an approved wholesaler trader. So just from my experience when I've been out in businesses, and generally, I've seen businesses have folders of the actual information they've recorded and retained for each customer and supplier, and then a summary sheet to just kind of pass to HMRC when they come in to show that the actual checks have been carried out and are documented in evidence. So penalties and case law. Criminal and civil actions were introduced for both wholesalers and trade buyers found buying alcohol from non-registered wholesalers. So penalties for wholesalers trading without having submitted their application to HMRC came into force from the 1st of April 2016. And trade buyers who buy alcohol from unregistered wholesalers will start from the 1st of April 2017. So these penalties can be equal to the potential lost revenue, which is your PLR, and will be in addition to a bill from HMRC for UK excise duty that should have been paid, and you're unable to evidence that you purchased the goods with excise duty on them by someone else beforehand. And if HMRC cannot access other traders earlier in that supply chain. So if the price paid seems too good to be true, then perhaps it is. So just remember, it's your responsibility to know your supplier and make sure that excise duty has been paid on the alcohol. So any alcohol found on premises of unregistered businesses may be seized, whether or not the duty has been paid. So just case law and B&M Retail Limited, a cautionary tale really. HMRC attended B&M's warehouse and detained a quantity of beer and wine that had been purchased from a supplier. It was a Ruby Trading Company Limited. HMRC claimed to detain the goods under SEMA, on the grounds that in their judgment on the balance of probabilities, excise duty had not been paid on the goods. So under B&M's terms and conditions of business, its suppliers are required to warrant that sales of alcohol to B&M are excise duty paid. So HMRC undertook an investigation during which they claimed to find no evidence to show that any of the goods were duty paid. So HMRC established that the supply chains traced back to companies that had disappeared and were therefore untraceable. So HMRC therefore formally seized the goods under the Excise Management Act (CMA). So HMRC subsequently assessed B&M for excise duty on the goods in excess of £5 million and served a notice of penalty assessment on the sum of just over £1 million. And the assessments were made on the grounds that an excise duty point had been created under the regulation and B&M was the person liable to excise duty under the regulation as a person holding the excise duty goods at the excise duty point. So the decision went to the first tier tribunal, with the excise duty liability then being transferred to the upper tribunal. The upper tribunal agreed with HMRC that if B&M's contentions were correct, then in particular in relation to imported excise goods, if HMRC were unable to establish how or when the goods concerned were imported, then the products would have to go untaxed, even though the person holding them was unable to show the duty had been paid. So such a result would be clearly contrary to the objective of the Council Directive to ensure that duties properly charged are collected. So the upper tribunal therefore ruled in favour of HMRC over the establishment of the debt. So the case continues on that one. And just as another example is Euro Wines Limited. In this case, Euro Wines purchased various excise goods from Galaxy Cash and Carry Limited. HMRC subsequently established that the goods had been supplied to Galaxy by Vanguard Breweries. HMRC discovered that the dress was in fact wasteland. HMRC concluded that excise duty had not been paid on the goods. HMRC assessed Euro Wines for excise duty in the sum of just over $300,000 and issued a 20% penalty for the potential lost revenue of $159,000. So Euro Wines appealed the excise duty assessment and the wrongdoing penalty. So just to kind of sum up really, so you're looking at, so having the alcohol wholesale registration number and printout is not sufficient. You are meant to take strong internal controls in place, carry out the fitted checks and check the integrity of your supply chain. And you do need strong, reliable evidence in place for your suppliers and your customers.
Well, great. Thank you, Anthony and Anelia. That was really, really good. And I'm really pleased to say that we've got a lot of questions. So we'll try and summarise some of them and just go through 4 or 5, if that's okay with you guys. So the first one was, at what point does the levy become payable?
Right, okay, it's Anthony speaking. I'll answer that one. Basically, when a chargeable soft drinks are packaged by a taxable person on premises in the United Kingdom, a chargeable event occurs on the removal of the chargeable soft drinks from that taxable person's premises. If the chargeable soft drinks are sort of made available free of charge before removal, which could happen from a taxable person's premises, a chargeable event would really occur at the time they're made available. Also, where chargeable soft drinks are imported into the United Kingdom, a chargeable event would occur on the first receipt of the soft drinks by a relevant person, what HMRC would refer to as the first recipient. The first recipient of the imported chargeable soft drinks is the first occasion on which the soft drinks are delivered to a place in the United Kingdom, basically to a relevant person's place of business. And just note that that doesn't mean a freight forwarder's yard for any freight forwarders who might just be holding the goods in transit prior to delivery, if that gives a little bit of comfort.
Thanks, Anthony. How would a company register for SDIL?
Right, well, this is a more tricky one, and over the last few months, actually I've been pressing HMRC in particular to confirm just how the registration process will take place. And I'm disappointed to say I haven't really had a very good answer on that one. What I would speculate is that they use a government platform called the Government Gateway, which the majority of their registrations are now done. And of course, with their digital drive, I would expect the Government Gateway to be the place where somebody would register and make returns for the SDIL, but that is yet to be confirmed. But I would be surprised if it was anything different, but we'll see.
Excellent, thank you. Will end users who check and validate a wholesaler's AWRS registration number via the gateway still be liable for wrongdoing penalties should the wholesaler subsequently be found unfit by HMRC, despite them passing the fit and proper test when registered?
If the end user has the appropriate due diligence in place, which addresses the risks of them obviously being involved in the supply of illicit product and can evidence that they've put this into practice, and the wholesaler was showing as an approved wholesaler on the online lookup service when the last check was made, then no action will be taken. We recommend that trade buyers record their checks, as I've said previously, or save the printout showing the online lookup check that when they've looked it up, they've printed it off. And any trade buyers shouldn't really enter into any further transaction with any unapproved or deregistered UK wholesalers.
Great, thanks, Amelia. Presumably, the end user, despite not needing to be registered, still has to follow their own due diligence when purchasing from a HMRC-approved wholesaler, and cannot completely rely on their registration as a cast iron guarantee the goods were duty paid when purchased. Is that for you, Amelia?
Yeah. As I've said before, just checking the online service is only forms part of your due diligence that the end user has to demonstrate.
Okay, thanks. And how often should the AWRS URN be checked? We have been advised informally by HMRC that it should be annually, but currently we only review low-cost suppliers every 2 or 3 years. So would we potentially be penalised by HMRC if we didn't change?
I would say that really you should perhaps in those circumstances, sorry Sam, I thought I'd answer this one. I would say I'd throw a word of caution about maybe 2 or 3 years. HMRC will go for you in the strongest possible terms if you haven't checked your suppliers recently, no matter what the relationship between the two of you might be. What I might just gently recommend to you is, I can understand you've got a good relationship with them. If nothing much has changed, perhaps a more gentle approach to an annual review might be, might help your cause a little bit. So rather than do a full-on review, if you're doing business with someone every day, you've already done full due diligence on them. I don't think there's any harm in doing maybe like a sort of a watered-down version of that to make sure nothing has changed. I think that's the key. Yeah, I think that's the key to it, in my opinion.
Thank you. And if we just go for one more question to finish off the webinar. The uptake for AWRS was very low initially. How many more registrations now have been made, or is it simply a case that many were rejected for not passing the fit and proper tests? Some basic generic statistics would be really helpful, as well as any view on why uptake was so low. Maybe this isn't the case now?
Well, from discussions with HMRC and my understanding, the uptake, initially was quite low, but that was due to, I would say, a lack of awareness of the scheme. But that has since been addressed by HMRC, and more applications have been received, particularly, I would say, as the 1st of April 27 fast approaching. Which is when retailers obviously have that obligation to ensure that the wholesalers are approved before trading with them. And I kind of think, this just off the top of my head, I think latest figures, something like maybe in the region of 7,000 applications have been made. So I don't know how that is in line with wholesalers out there, but as far as I'm aware, that's kind of what we're looking at.
Perfect, thank you. Well, thank you very much for your time today, and I just wanted to confirm that we will be sending a recording of this webinar to everyone who had registered, as well as the handout that we prepared with the detail of what was discussed in today's webinar. So thank you very much for attending the the webinar on the 26th of April, and I look forward to seeing you at future webinars.